former special counsel Jack Smith was in the hot seat there yesterday. Lawmakers grilled him about his investigation into President Trump's attempt to overturn the 2020 election.
Smith was subpoenaed to testify as part of a Republican-led investigation into the 2020 election interference case that the president sought publicly. In the closed-door hearing, Smith defended his prosecutorial decisions. He said his team found, quote, proof beyond a reasonable doubt that Trump had engaged in a criminal scheme to overturn the election.
NBC News senior justice reporter Ryan Riley joins us now with more on this. Ryan, good morning. So this is a hearing that took place behind closed doors, even though Smith wanted it to happen in public. Tell us more about what he had to say and how Democratic lawmakers are reacting.
Yeah, I mean, essentially what we know from his testimony is that he emphasized that he had a very solid case against Donald Trump and that they could have gotten a conviction in court had this case been allowed to go to trial. But because Donald Trump was elected, this case was dismissed. Under Justice Department precedent, you cannot continue a case against a sitting president. So it wasn't about the merits of the case so much as it was just about the overall Justice Department policy. But, you know, based on that testimony, essentially what you're looking at here is a battle.
It's John, and what I learned today shocked me. Jack Smith has filed a bombshell court motion demanding Trump's sworn testimony, presenting evidence of an unprecedented criminal effort to subvert the 2020 election, piercing immunity claims and compelling testimony in a full-scale legal assault on presidential accountability. The filing fundamentally changes Trump's legal situation. You cannot overstate how monumentally serious this is. Trump genuinely believed he was done with Smith. Trump was convinced that when he got elected president, Smith would simply fade away into obscurity. Trump even vowed publicly to fire Smith the moment he stepped back into the Oval Office. But Smith just made absolutely certain that Trump's legal nightmare is not going anywhere.
Between Republicans who are seeking to undermine this investigation and undercut it, and Jack Smith, who's saying that this was all very warranted and that they did things by the book and correctly. And so, you know, the fact that this wasn't public, that's something that Jack Smith wanted, but that's something that Republicans denied. And I think that Raskin went to the camera and actually talked about this afterwards. Take a listen.
Chairman Jordan made an excellent decision in not allowing Jack Smith to testify publicly, because had he done so, it would have been absolutely devastating to the president and all the president's men involved in the insurrectionary activities of January the 6th. His report speaks for itself in terms of January the 6th and the indictments that were handed down. And the other report should be public. I mean, that's just absolutely aberrational that it's not public.
So thus far, we haven't seen any leaks from Republicans about what exactly happened during this testimony, but I think that's something we could potentially look forward to in the future, Joe.
What has the reaction been like from Republicans and the Trump administration?
Smith just made sure that Trump is going to have to answer questions under oath about his criminal conduct. And now courts are going to have to grapple with the unprecedented question of whether to compel a sitting president's testimony despite his current occupancy of the White House. This is a constitutional crisis unfolding in real time before our very eyes, and the implications are staggering. We have one set of laws in this country, and they apply to everyone equally, regardless of wealth, power, or political position. Applying those laws, collecting facts, that is what determines the outcome of an investigation. Nothing more and nothing less. The prosecutors in Smith's office are among the most talented and experienced in the entire Department of Justice. They have investigated this case according to the highest ethical standards.
This is what we know, that Donald Trump laid the groundwork to try to overturn the 2020 election even before he lost, knowingly pushing false claims of voter fraud and, quote unquote, resorting to crimes in his failed bid to cling to power. That's according to a newly unsealed court filing from prosecutors that lays out fresh details from the landmark criminal case against the former president here. So we're going to get into some of this. We're going to bring into the conversation to talk about all of this our friend, former federal prosecutor and legal analyst, Nima Rahmani. He joins me. Nima, good to see you here. I just have to point out that we're talking about the 2020 election, 33 days away from the 2024 election. This is still prime of place in so many's minds, including none other than the special counsel, Jack Smith and his team, who has brought this case in the election subversion case in D.C. Judge Tanya Chutkin getting this filing today. It was about 165 pages.
And they will continue to do so as this case proceeds. It is critically important to note that the defendants in this case must be presumed innocent until proven guilty beyond a reasonable doubt in a court of law. To that end, Smith's office will seek a speedy trial consistent with the public interest and the rights of the accused. They very much look forward to presenting their case to a jury of citizens. In conclusion, the dedicated public servants of the Federal Bureau of Investigation work tirelessly every day upholding the rule of law in our country, and Smith expressed deep pride in standing shoulder to shoulder with them. Let me explain exactly what Smith just did and why it changes everything.
And then putting it out there for everyone to see. Parts of it, yes, were redacted. Names of those not charged in this as well here. I guess I got to ask you, Nima, was it just embarrassing for this to be revealed for Donald Trump, or did we glean any new information about what he did both before and after the 2020 election? From my vantage point here, and I've read some of it, a lot of it, yes, salacious, yes, juicy, but not necessarily new.
Not necessarily any smoking guns, Andrew, but what I would say is a lot of what we knew was alleged by Jack Smith in the superseding indictment, and even going back to the January 6th committee, we're seeing some of that evidence come through from what I call private actors, right? Family members of the president, some of whom were, of course, White House staff, but private lawyers and, importantly, campaign officials. So not necessarily any new smoking gun type evidence, but the sources of the evidence matter, because we know, because of the Supreme Court's very broad presidential immunity opinion, nothing that relates to official acts that come in. So, all the allegations related to the Department of Justice.
Smith submitted a new court filing that goes into excruciating detail about the evidence of Trump's criminal conspiracy. Smith is talking about recordings of Trump's own voice giving direct orders to find votes. Smith is talking about documents showing Trump orchestrating the fake elector scheme. Smith is talking about witness testimony from people who were in the room when Trump was planning to overturn the election. Smith is talking about communications between Trump and his co-conspirators. Smith is basically laying out a comprehensive case that proves Trump engaged in a criminal conspiracy to subvert the election. And then Smith explicitly asks the court to compel Trump's testimony. Smith is saying, we have all this evidence, we have all these witnesses, we have all these recordings and documents, but we need Trump to testify under oath so Trump can explain his criminal conduct in his own words. That is a devastating legal move because it puts Trump in an absolutely impossible position. If Trump testifies, Trump is going to incriminate himself by lying under oath or by admitting to the criminal conduct. If Trump refuses to testify, Trump looks guilty, and the court can draw negative inferences from his refusal. The timing of this filing is also absolutely critical because it is coming at a moment when Trump thought he had escaped legal jeopardy. The Georgia case got dismissed. Other cases have been paused or dismissed entirely. Trump came back into office thinking he was going to be able to control the DOJ and make all his legal problems disappear. But Smith, who is not under Trump's control anymore because Smith was appointed before Trump got elected, just filed this devastating document that reopens all the legal questions about Trump's criminal conduct. Smith's filing is saying that they are not done with this, that they have evidence, that they want Trump's testimony, that they are going to push forward on this case regardless of what Trump wants. And Trump cannot fire Smith fast enough to stop this filing from being considered by the courts. The filing is already out there. The courts are already going to have to respond to it. Trump's testimony is already being demanded. Trump's immediate legal nightmare just got worse, not better. What makes Smith's filing so powerful is the specificity of the allegations. Smith is not making vague accusations that Trump tried to overturn the election. Smith is saying Trump directly ordered people to find votes. Smith is saying Trump personally orchestrated the fake elector scheme. Smith is saying Trump pressured state officials. Smith is saying Trump tried to disrupt Congress's certification. And Smith is backing up every single one of these allegations with evidence, recordings, documents, witness testimony. When a special counsel files a court document with this level of detail and this much evidence, courts take it seriously. Courts understand that Smith has done extensive investigation. Courts understand that Smith's allegations are backed up by real evidence. So when Smith asks for Trump's testimony, courts are probably going to take that request seriously too. Courts are probably going to want to hear what Trump has to say in response to the evidence Smith has compiled. The immunity issue is also critical because Smith's filing essentially rejects Trump's immunity claims. Trump has been arguing that anything he did as president is protected by presidential immunity, and courts cannot investigate or prosecute him for those actions. But Smith's filing argues that Trump's campaign to overturn the election involved unofficial acts that fall outside immunity protection. The filing specifically mentions communications with Vice President Pence and the alternate slate scheme and the pressure on state officials, arguing that all of these were unofficial acts done in Trump's capacity as a private citizen engaged in a political campaign, not official presidential acts done in Trump's official capacity. If courts agree with Smith's argument, then Trump's immunity shield collapses. Then Trump can be prosecuted. Then Trump can be compelled to testify. That is a massive legal blow to Trump because the immunity claim has been Trump's primary defense against all the criminal allegations. And here is what is wild. Trump vowed to fire Smith the moment he got back into the White House. Trump said he was going to immediately remove Smith as special counsel, but Smith anticipated this. Smith finished his investigation. Smith compiled his report. Smith filed his court documents. And now, even if Trump fires Smith, even if Trump removes Smith from office, the court filings are already submitted. The allegations are already on the record. The demand for Trump's testimony is already being considered by courts. Trump can fire Smith, but Trump cannot undo Smith's court filings. Trump can fire Smith, but Trump cannot make the evidence disappear. Trump can fire Smith, but Trump cannot prevent courts from ordering Trump's testimony. Smith basically got all his work done before Trump could fire him. Smith filed the documents that are going to haunt Trump legally for the foreseeable future. And now courts are going to have to decide whether to compel Trump to testify under oath about criminal conduct that Smith has documented comprehensively. The bipartisan calls for accountability are also starting to intensify because this filing has reignited attention on Trump's conduct during the 2020 election and January 6th. Democrats are saying, finally, here is the evidence proving Trump engaged in a criminal conspiracy. Democrats are saying this is why Trump needs to be held accountable. Democrats are saying Trump needs to testify under oath and explain his criminal conduct. Some Republicans, the ones who still believe in the rule of law, are also looking at Smith's filing and recognizing that the evidence is serious and substantial. Republicans are starting to ask themselves, what did Trump actually do and what does the evidence really show? And some Republicans are starting to think that maybe Trump does need to answer these allegations. That kind of bipartisan seriousness about the allegations is dangerous for Trump because it means he cannot just dismiss Smith's filing as a partisan witch hunt. The evidence is real. The allegations are serious, and courts are going to have to take the demand for testimony seriously. So let us dig deeper into what is actually in Smith's new filing and why this demand for Trump's testimony is such a game changer in Trump's legal situation. Smith spent months investigating Trump's efforts to overturn the 2020 election. Smith interviewed witnesses. Smith reviewed documents. Smith analyzed communications. Smith listened to recordings. And Smith compiled all of that evidence into a comprehensive report that documents what Trump did and how he did it. The report found probable cause for charges on election conspiracy. The report details Trump's direct orders to find votes. The report documents Trump's role in orchestrating the fake electors scheme. The report shows Trump's pressure on state officials to change election results. It is all there in the report. It is all documented. It is all supported by evidence. And now, Smith's new court filing is making that evidence public and demanding Trump's testimony about it. The recordings of Trump's own voice are the centerpiece of the evidence because they are direct proof of Trump's criminal conduct. Trump apparently recorded conversations where he directly ordered people to find votes. Trump recorded conversations where he discussed deploying fake electors. Trump recorded conversations where he talked about disrupting the certification process. When Smith files these recordings in court, when judges listen to Trump's own voice discussing criminal activity, it becomes nearly impossible for Trump to deny what he did. Trump can claim he was taken out of context. Trump can claim the recordings are misleading. But when judges and juries hear Trump's own voice saying things about overturning the election, that is direct evidence of Trump's knowledge and intent. That is the kind of evidence that transforms a case from circumstantial to overwhelming. The documents showing Trump orchestrating the fake elector scheme are also devastating because they create a paper trail. There are apparently emails showing the planning. There are apparently memos showing the strategy. There are apparently notes from meetings where Trump discussed what he wanted to happen. When you have got documents, you have got hard evidence that cannot be disputed or spun away. Documents do not lie. Documents show what people actually said and planned at the time they said and planned it. And Trump's documents apparently show a deliberate, systematic plan to create fake electoral certificates and submit them to Congress. That is fraud. That is forgery. That is a federal crime. And Trump's documents prove Trump was involved in planning it. The witness testimony from people who were in the room with Trump is also critical evidence. These are people who heard Trump directly discuss his plans. These are people who participated in some of the efforts to overturn the election. These are people who can testify about what Trump said and did. When multiple witnesses give consistent testimony about the same events, when they describe the same conversations, when they recount the same directives from Trump, the evidence becomes overwhelming. A defense lawyer can try to impeach one witness. But when you have got multiple witnesses saying the same things, corroborating each other, all describing Trump's deliberate conduct, defending against that testimony becomes nearly impossible. Smith's filing apparently details testimony from multiple witnesses who were inside Trump's inner circle during his effort to overturn the election. That is the kind of evidence that proves criminal intent beyond reasonable doubt. The pressure on state officials is also documented in Smith's filing with emails and phone records showing Trump directly contacting governors and secretaries of state and election officials. Trump apparently asked them to find additional votes for him. Trump apparently asked them to overturn their state's election results. Trump apparently pressured them to act contrary to their official duties. That is not one person expressing concerns about election integrity. That is a systematic campaign to get elected officials to ignore the will of the voters and change election results in Trump's favor. That is a conspiracy. That is multiple people working together to defraud the United States. That is a federal crime. And Smith apparently has documentation of the entire conspiracy. The communications with Pence are also relevant because they show Trump pressuring the vice president to not certify the election results. Trump apparently asked Pence to reject the state certifications when Congress was counting electoral votes on January 6th. Trump apparently believed that Pence had the authority to reject state certifications and declare Trump the winner. But that is not how the Electoral Count Act works. Pence did not have that authority. And Trump's attempts to pressure Pence to reject state certifications were illegal attempts to overturn the election. Smith's filing apparently documents these communications in detail, showing Trump's knowledge that what he was asking Pence to do was outside Pence's legal authority, but Trump was asking him to do it anyway. Now, let us talk about Smith's argument that these were unofficial acts that fall outside immunity protection. Trump has been arguing that everything he did as president is protected by presidential immunity because he did it in his official capacity. But Smith is arguing that Trump's campaign to overturn the election was not done in Trump's official capacity as president. Trump was doing these things as a candidate trying to win a presidential election. Trump was doing these things as a politician trying to maintain power. Trump was not doing these things as president performing official presidential duties. So immunity does not apply. This argument is legally sophisticated because it tries to carve out space for prosecuting Trump, even though Trump was president at the time he engaged in the conduct. And if courts accept Smith's argument, if courts agree that Trump's conduct was unofficial and outside immunity protection, then Trump can be prosecuted and compelled to testify. The demand for Trump's testimony is also strategically brilliant because it puts Trump in an impossible position. If Trump agrees to testify, Trump has to answer questions under oath. Trump cannot lie under oath without committing perjury. Trump cannot refuse to answer questions without being held in contempt of court. So Trump basically has to choose between incriminating himself by telling the truth or committing perjury by lying. Either way, Trump loses. If Trump refuses to testify, Trump looks guilty and the court can draw negative inferences from his refusal. Courts typically assume that if a defendant refuses to testify, it is because the testimony would be damaging. So Trump's refusal to testify becomes evidence of guilt. Trump is basically trapped. Trump has to either testify and incriminate himself or refuse and look guilty. There is no good option for Trump. The timing of Smith's filing right after Trump came back into office is also strategically important because it forces the issue immediately. Trump cannot ignore it. Trump cannot hope it goes away. Trump cannot wait for years while appeals drag on. Smith's filing is in court right now. Courts are going to have to rule on the demand for testimony right now. Trump is going to have to respond to the allegations right now. Trump does not get to have a honeymoon period as president where he can ignore his legal problems. And Smith made sure that Trump's legal problems are front and center from day one of his presidency. That is going to consume Trump's administration. That is going to dominate the news cycle. That is going to force Congress and the public to confront questions about Trump's criminal conduct. The broader legal implications are also significant because this case could set precedent about presidential immunity. If courts agree with Smith that Trump's unofficial acts fall outside immunity protection, then future presidents will know that they can be prosecuted for political conduct even if they were president at the time they engaged in the conduct. That is a major limitation on presidential immunity. That is a major expansion of the court's ability to prosecute presidents for criminal conduct. It could reshape presidential power going forward. And all of this is being played out in Trump's case right now. All of these legal questions about immunity and presidential power are being litigated in real time as Trump sits in the Oval Office. Smith's filing essentially guarantees that Trump's testimony demand is going to be taken seriously by courts. Smith did not file some vague request for testimony. Smith filed a detailed, evidence-backed, legally sophisticated document that makes a compelling case for why Trump's testimony is necessary. Smith laid out specific evidence. Smith explained why the evidence supports criminal charges. Smith explained why Trump's testimony is essential to clarifying what happened. And Smith backed up every assertion with documentation. When a special counsel files a document like that, courts understand that the request is not frivolous or politically motivated. Courts understand that there is a legitimate legal basis for the request. So courts are going to take the demand for testimony seriously. Courts are probably going to hold hearings. Courts are probably going to consider whether to compel Trump's testimony. And the likelihood that courts will order Trump's testimony is now very high. Trump's immunity defense has been severely weakened by Smith's argument that Trump's conduct was unofficial. Trump has been relying on immunity as his primary legal defense against all the criminal allegations. But if Smith's argument succeeds, if courts agree that Trump's conduct was unofficial and falls outside immunity protection, then Trump's entire defense strategy collapses. Trump can no longer hide behind immunity. Trump can no longer claim that courts have no power to investigate his conduct. Trump can no longer claim that he is protected from prosecution. Trump becomes just another person who can be prosecuted for criminal conduct. And once immunity is gone, Trump's legal exposure becomes enormous. Trump can face criminal charges. Trump can be compelled to testify. Trump can be convicted and punished just like any other criminal defendant. That is a massive legal defeat for Trump. The demand for Trump's testimony is going to force Trump into an impossible choice. Trump either has to testify under oath and risk incriminating himself or refuse to testify and look guilty. There is no middle ground. There is no way for Trump to avoid the choice. Trump can try to delay the proceedings. Trump can try to appeal the demand for testimony. Trump can try to get Congress to protect him. But ultimately, if courts order Trump's testimony, Trump has to either comply or face contempt charges. And either way, Trump loses. If Trump testifies and admits to the criminal conduct, Trump has incriminated himself and given prosecutors evidence to use against him in court. If Trump refuses to testify, Trump looks guilty, and the court can assume that his testimony would be damaging. So Trump is basically trapped. The only way Trump avoids this trap is if courts reject Smith's demand for testimony. But given how strong Smith's filing is, given how much evidence Smith has compiled, given how legally sophisticated Smith's arguments are, the likelihood that courts are going to reject the demand for testimony is low. This is going to intensify the legal and political pressure on Trump's presidency. Trump thought when he got elected president, his legal problems would go away. Trump thought he could control the DOJ and make investigations disappear. Trump thought he would be able to pardon himself or his allies and escape legal consequences. But Smith's filing proves that Trump's legal problems are not going away. Smith's filing proves that Trump's legal exposure is actually expanding. Smith's filing proves that courts are going to take Trump's criminal conduct seriously, even though Trump is currently president. And now Trump has to deal with the fallout from Smith's filing while he is also trying to govern as president. That is going to consume Trump's administration. That is going to consume Trump's focus. That is going to make it impossible for Trump to focus on his agenda. Here is what is going to happen in the immediate future. First, courts are going to schedule briefing on Smith's filing. The parties, Smith's team, and Trump's legal team are going to file written briefs explaining their positions on whether Trump's testimony should be compelled. Trump's lawyers are going to argue that Trump should not have to testify, that presidential immunity protects Trump, that the demand for testimony is unconstitutional. Smith's team is going to argue that the evidence supports criminal charges, that Trump's conduct was unofficial and outside immunity protection, that Trump's testimony is essential to the case. Judges are going to read these briefs and understand the full scope of the legal dispute. Second, there are probably going to be oral arguments before judges. Trump's lawyers and Smith's team are going to appear before judges and make their arguments in person. Judges are going to ask tough questions. Judges are going to probe the legal arguments. Judges are going to try to understand whether Trump's conduct was official or unofficial, whether immunity applies, whether Trump's testimony can be compelled. These oral arguments are going to be intense because the stakes are so high. These oral arguments are going to be covered extensively by the media. These oral arguments are going to show the American people how serious the legal allegations against Trump are. Third, judges are going to issue rulings on whether Trump's testimony can be compelled. If judges rule that Trump's conduct was unofficial and outside immunity protection, judges are going to order Trump's testimony. If judges rule in Trump's favor, judges are going to dismiss Smith's demand for testimony. But given how strong Smith's filing is, given how much evidence Smith has presented, judges are more likely to rule in Smith's favor. So Trump is probably going to be ordered to testify. And then Trump is going to face the choice of complying or refusing. If Trump refuses, Trump can face contempt charges. If Trump complies, Trump has to testify under oath. Fourth, Congress is going to become involved in this dispute. Congress might demand that Trump cooperate with Smith's investigation. Congress might hold hearings about Trump's efforts to overturn the election. Congress might use Smith's evidence as a basis for impeachment proceedings. The demand for Trump's testimony is going to force Congress to confront the question of whether Trump engaged in criminal conduct to overturn the election. And Congress is going to have to decide whether to act on that evidence or ignore it. The bigger picture here is that Trump's legal nightmare is not ending. Trump's legal nightmare is escalating dramatically. Smith's filing is the most serious legal challenge Trump has faced since coming back into office. Smith has compiled overwhelming evidence of criminal conduct. Smith has demanded Trump's testimony, and courts are going to have to rule on whether to compel that testimony. If courts order Trump's testimony, Trump becomes the first sitting president ever to be compelled to testify in a criminal case. That is an unprecedented moment in American history. That is a moment where the justice system is directly confronting a sitting president with evidence of criminal conduct and demanding accountability. It is going to be ugly. It is going to be contentious. It is going to consume Trump's presidency, but it is also going to be a defining moment for whether the rule of law applies to everyone, including presidents, or whether presidents are above the law. Smith's filing forces that question into the open. Smith's filing forces courts to decide. And the answer that courts give is going to shape American law and presidential power for generations to come. This is absolutely historic. This is absolutely wild. The next phase of this legal battle is going to reshape everything about Trump's presidency and American democracy itself. The evidence is overwhelming. The demand for testimony is unprecedented, and the outcome will determine whether the Constitution's promise of equal justice under law applies to the most powerful person in the world, or whether we have created an imperial presidency that answers to no one. This is the moment where America decides what kind of country we are going to be.